Have you ever made a deal, maybe for something significant, like a car or, I don't know, a boat, sealed it with a handshake, maybe even started the payment, and then suddenly the other person gets cold feet? You're left wondering, wait, can they just walk away because we didn't sign some fancy formal contract? Today, we're diving deep into exactly that. We're tackling the rule that governs these situations, the statute of frauds, specifically under the Uniform Commercial Code, UCC 2201. This is absolutely crucial if you're dealing with sales of goods, anything worth $500 or more. Our mission, to really understand how modern law can actually save an agreement that, well, the old common law might have just tossed out. And we'll model this by dissecting a classic case involving a sailboat dispute, Cohn v. Fisher. Okay, let's unpack this.
Yeah, that's a great way to frame it. The statute of frauds, it often feels like this impenetrable wall, right, designed to stop claims. But the UCC, interestingly, punched some holes in that wall. It created not just one, but three paths, really, to enforce an oral contract for goods. So we're going to analyze these meticulously. First, we'll look at what counts as a sufficient writing, which is surprisingly minimal. Second, the effect of admitting the contract in court, the judicial admission exception. And third, what happens when there's been partial performance.
All right, let's start with path number one, probably the most common one, the written memorandum under UCC 22011. Now, for anyone listening who remembers the older, stricter common law rules, what's the UCC's general take on the writing requirement? And, I mean, how much did this really change things?
Well, the general rule under 22011 is that a contract for selling goods worth $500 or more isn't enforceable unless there's some kind of writing. Enough writing to show a contract for sale was actually made. The big shift, the really radical part, is the UCC's flexibility. Common law. It demanded everything in writing. All the key terms, price, delivery details, quality specs, you name it. The UCC flat out says the writing isn't insufficient just because it leaves out or even incorrectly states a term agreed upon. The goal shifted, you see. It's about preventing outright fraud based on fabricated claims, not about penalizing imperfect paperwork. If the writing gives a basis for believing a real deal exists, that's often enough.
Wow, okay, that really does lower the bar significantly compared to what you might expect. And this is where it gets really interesting because we can test just how low that bar is using our sailboat case. Let's analyze Cohn v. Fisher. First, can you lay out the legally dispositive facts for us?
Sure. So Cohn was selling his boat, a 30-foot sloop named the Dark Wind. Fisher agreed, orally, to buy it for $4,650. The crucial fact, the one everything hinges on initially, is the deposit check. Fisher wrote Cohn a check for $2,325, exactly half the price. And critically, on the memo line he wrote, deposit on O sloop, Dark Wind, full amount $4,650. But then pretty quickly, Fisher changed his mind. Buyer's remorse kicked in, he stopped payment on the check and refused to complete the purchase.
Right, classic scenario. So what was the core legal issue the court had to grapple with?
The precise legal question was, did that check, just the check itself with that specific notation on the memo line, count as a sufficient written memorandum under UCC 22011, enough to make the oral agreement for the boat enforceable against Fisher?
Got it. And what rule of law did the court apply here? Could you state the full black-letter rule and maybe break down its testable elements for us?
Absolutely. The rule is UCC 22011. It basically says a writing is good enough if it indicates a contract was made and it's signed by the person you're trying to enforce it against. The official comments from the UCC drafters emphasize there are really only three essential things the writing must have. These are the elements we test. 1, the writing has to indicate a contract for sale exists. 2, it must be signed by the party to be charged that's usually the defendant, the one trying to get out of the deal. And 3, it has to specify a quantity.
Okay, thank you. That's clear. Now for the court's elemental analysis. Let's walk through this element by element. How did the court apply that first element, the requirement for an indication of a contract for sale? How did a check memo meet that?
Well, the court looked right at that memo line. Deposit on O sloop, Dark Wind, full amount, $4,650. They reasoned that words like deposit and stating the full amount strongly suggest a real transaction had occurred. Remember, the writing doesn't have to be the contract. It just needs to provide some objective evidence that the later oral testimony about a contract isn't just made up, that it rests on a real transaction. The court found those details on the check, provided that reasonable basis. So, element 1, check, met.
Understood. Seems logical when you put it that way. Now, what about the second element, being signed by the party to be charged?
This one was pretty straightforward for the court. The party being charged was Fisher, the buyer trying to back out. And, well, he wrote the check. He signed it as the drawer. The UCC's definition of signed is incredibly broad. It's basically any symbol made or adopted with the intention to authenticate the writing. Fisher's signature on his own check clearly fit. Element 2 was easily met.
Okay, 2 down. Finally, how did the court handle the third element, the need for an express quantity term, especially since the memo just named the boat, right? It didn't say quantity 1.
Right. That's a good point. The quantity term is obvious with bulk goods, but here it's a single unique item, the dark wind. The court reasoned that when the contract is for one specific identifiable thing, like a particular boat, mentioning that specific item is sufficient to state the quantity. The quantity is implicitly 1. So specifying dark wind satisfied the quantity requirement. Element 3 was also met.
Okay, so the writing indicated a contract, it was signed by Fisher, and it specified the quantity as 1 boat. After analyzing all those elements, what was the court's final conclusion regarding UCC 2201?
The court concluded that Fisher's check, even though it was just a check with a memo notation, fully satisfied all 3 requirements of UCC 22011. As a result, Fisher's statute of frauds defense failed. The oral contract for the $4,650 sailboat was deemed entirely enforceable against him. It's a stark reminder that under the UCC, you really don't need a formal, multi-page contract to have a binding agreement for goods.
That is powerful stuff, and it really highlights the UCC's practical approach. To make sure everyone listening really gets how flexible this writing requirement is, let's switch gears with a hypothetical, something totally different. Imagine you're a restaurant owner buying, say, 5,000 pounds of frozen imported squid. Big order. You quickly scribble on a nearby napkin, 5K pound squid at 3 pounds, you sign it, and the seafood supplier signs it too. Is that flimsy napkin potentially enforceable under the UCC?
The squid napkin. Yes. Based on Cohn and the UCC's philosophy, that napkin would almost certainly satisfy 22011. Let's check the elements. Does it indicate a transaction? Yep. 5K pound squid at $3 implies a sale. Is it signed by the party charged? You said both signed it, so yes. Does it specify a quantity? Absolutely, 5K pounds. All the other details, what kind of squid exactly, when it's delivered, payment terms, those can be missing from the writing. They don't kill the enforceability under the statute of frauds. Those terms would just be proven later through testimony or filled in by the UCC's own gap filler rules if necessary.
Okay, so the check worked for Cohn, and even a napkin might work. But let's push this. What if, hypothetically, Fisher had paid Cohn the deposit entirely in cash? No check, no memo line, maybe just a verbal agreement and a wad of bills. Is the deal dead then? What's the second escape route the court looked at?
Good question. If there's truly no writing that satisfies 22011, you move to the exceptions in 22R1. The second path we discussed is judicial admission, found in 2013. This one's fairly intuitive. Even without a writing, an otherwise valid oral contract becomes enforceable if the party who's trying to deny the contract admits in a legal setting, like in court testimony, depositions, or formal responses, that a contract for sale was, in fact, made.
That raises an interesting policy point. Why did the UCC writers put that exception in? Doesn't it kind of undercut the whole point of needing a writing in the first place? If the statute of frauds is there to prevent false claims?
Well, yes and no. The purpose of the statute of frauds is primarily to protect someone from being forced into a contract they genuinely didn't make, based solely on potentially perjured testimony. But if that same person gets up in court, under oath, and says, yes, okay, fine, we did have an agreement, then the risk of fraud disappears, right? They've admitted it. The statute's protective purpose is fulfilled at that moment. To then let them use the statute to escape the deal they just admitted to would, ironically, turn the statute of frauds into a tool for fraud, allowing them to renege on a real bargain.
Okay, that makes sense. It prevents the statute from being used dishonestly. So applying that back to Cohn v. Fisher, how did Fisher's own actions or words end up satisfying this judicial admission exception? Did he actually admit it?
Yes, according to the court's opinion, he did. The court pointed out that during pretrial procedures, specifically in his depositions and his formal answers to requests for admission, Fisher actually conceded that, yes, an oral agreement to buy the dark wind for the stated price had been reached. So because he admitted the contract's existence in that formal judicial context, the court said that even if the check hadn't been a sufficient writing, the contract would have become enforceable against him under 22013. Though it's important to note, this exception only enforces the contract up to the quantity of goods admitted. Here, since he admitted to buying the one boat, it covered the whole deal.
Right, one boat admitted, one boat enforced. Okay, let's consider the final path. What if there was no sufficient writing and Fisher had, maybe, cleverly avoided admitting the contract in court? Is there still another way Cohn could enforce the deal? How does partial performance fit in?
Yes, there's one more key exception. Partial performance, under UCC 22013C. This says an oral contract is enforceable, again, even without a proper writing or admission, but only concerning specific goods. It applies in two scenarios. First, for goods where payment has been made and accepted, or second, for goods which have been received and accepted by the buyer. Action speaks louder than words, essentially.
Now, you mentioned earlier that the UCC changed how partial performance works compared to the old common law. Under common law, sometimes just a small partial payment could make the entire oral contract enforceable, right? How did the UCC limit that? Maybe thinking about our squid example again.
Exactly. That limitation is a really critical change the UCC introduced. Under 22013, the contract is enforceable only for the quantity of goods for which payment has been made and accepted, or which have been received and accepted. So back to the squid. If you orally agree to buy 5,000 pounds, but you only pay for, say, 1,000 pounds, and the seller accepts that payment, the contract is only enforceable for those 1,000 pounds you paid for, not the full 5,000. It prevents a party from leveraging a small act of performance into proof of a much larger disputed contract, especially with divisible goods like pounds of squid.
Wait, I need to make sure I understand this divisibility point clearly. Fisher paid half the price with his deposit check. Why didn't that partial payment only make half the contract enforceable under this rule? How did the court justify enforcing the whole contract for the boat based on a partial payment?
That's the crucial distinction between divisible and indivisible goods. The check Fisher gave was definitely payment made, and Cohn accepting it triggered the partial performance rule. The reason it validated the entire contract comes down to the nature of the good being sold at dark wind. A sailboat is generally considered indivisible. You can't really enforce a contract for the sale of the front half of a boat. So the commentary and case law interpreting 2201C generally hold that for a single indivisible item, any accepted partial payment makes the entire contract enforceable. The logic is that paying a substantial deposit on one specific thing strongly indicates an agreement for that whole thing.
Okay, that clarifies the indivisible item aspect, but what about the fact Fisher stopped payment on the check? If Cohn never actually got the cash, doesn't that undo the payment made and accepted part? Why was the stop payment order irrelevant?
The court addressed that directly. They ruled that stopping payment after the check had been delivered and accepted was legally irrelevant to the statute of frauds question itself. The key moment for enforceability under 22013C was the acceptance of the check by Cohn as payment. Once Cohn took that check representing the deposit, the partial performance exception was triggered and the oral contract became enforceable. Fisher stopping payment later simply constituted a breach of his promise to pay embodied in the check. It gave Cohn grounds to sue either on the check itself or on the underlying obligation to pay for the boat, but it didn't retroactively make the already enforceable contract unenforceable again.
Wow. Okay, so the moment of acceptance of that check was incredibly powerful legally. It basically locked Fisher in three different ways we've discussed. So let's bring this all together. We've dissected Cohn v. Fisher and explored these three distinct paths around the statute of frauds for goods over $500. For the listener trying to synthesize this, can you boil it down into a final, actionable, step-by-step checklist they could use for issue spotting or analysis?
Absolutely. Connecting this back to a structured legal analysis framework, here's your UCC statute of frauds checklist when you encounter an oral agreement for goods worth $500 or more. Step 1. Look for a writing, 2201. Is there any writing signed by the party trying to get out of the deal that indicates a contract for sale and mentions a quantity? Remember how low the bar is? Check memos, emails, even napkins can count if they meet these three minimal requirements. If yes, you're likely done, the contract's enforceable. Step 2. Check for admissions, 22013. If there's no sufficient writing, has the denying party admitted the contract exists in a formal legal context, court filings, testimony, depositions? If yes, the contract is enforceable, but critically, only up to the quantity they actually admitted to. Step 3. Analyze performance, 22013C. If you have no writing and no admission, look at actions. Have goods been received and accepted by the buyer? Or, as in Cohn, has payment been made and accepted by the seller? If yes, the contract is enforceable, but again, with that crucial UCC limitation, only for the quantity of goods paid for or received, unless, of course, the item is indivisible like the sailboat, in which case partial performance validates the entire agreement.
That step-by-step structure is incredibly helpful. This deep dive really shows how the UCC takes a very pragmatic approach to these common situations. It seems less concerned with rigid formalities and much more focused on figuring out if a genuine bargain was struck and preventing parties from using technicalities to escape deals they actually made. So here's a final provocative thought for you to chew on, building on that Cohn case. If the law says that accepting that deposit check made the whole sailboat contract instantly enforceable against Fisher, regardless of his later stop payment, What could a buyer like Fisher have done differently at the time of giving the deposit if they genuinely wanted to preserve an option to back out, maybe after a sea trial or inspection? What specific language might they have needed to put on that check memo, or perhaps in a quick note handed over with the check, to make that payment truly conditional and avoid that immediate binding enforceability? Think about the difference between calling it a deposit versus maybe earnest money subject to satisfactory survey, something to mull over.